And I'd like to introduce our wonderful presenters today. Steve Collis is a law professor at the University of Texas School of Law and the faculty director of Texas's Beck Laughlin First Amendment Center and Law Religion Clinic. And prior to that, he was the Olin Darling Research Fellow in the Constitutional Law Center at the Stanford Law School. Alexander Dushku is a shareholder at Curtin McConkie and is a member of the firm's First Amendment and Religious Organizations, Litigation, and Appellate sections. He has experience litigating a broad range of religious liberty cases, including the United States Supreme Court. And Alexander is the primary outside legal counsel for the Church of Jesus Christ of Latter-day Saints in matters of religious freedom and public policy. But not only are Stephen and Alexander both widely recognized scholars in the field of religious freedom, but as our executive director, Gayla Sorensen, shared with me, they are not like other scholars up in their ivory towers, but they're down to earth, very practical approach, teaching advocates, a practical approach to law and policy about religious freedom, and active leaders in the J. Reuben Clark Law Society as the chair and vice chair of Religious Freedom Committee. And without further ado, we'll turn it over to Steve and Alexander.
Well, thank you so much, Erin, and thank you for everyone who has taken time out of their busy schedules to join us today. I'm thankful for the J. Reuben Clark Law Society for hosting this and providing the Zoom room, and I am especially thankful for Alexander taking time out of his busy schedule to join me. I do want to emphasize, please do put your questions in the chat. I doubt, given how many, we have over 200 people and more coming, so I doubt we'll be able to get to all of them, but there is no stupid question. There is no offensive question. Please just type it in. We'll get to the ones we can. We'll try to combine them where possible. I recognize that COVID-19 has become something that probably every person on earth has an opinion on, and many of those opinions are very strongly held. My hope is today that all of us, as Alexander and I are speaking, but also as we're listening to your questions, can have open minds, and we won't allow our already strong opinions to prevent us from learning from one another, because I do look forward to hearing your comments and questions in the chat as much as I look forward to hearing to what Alexander has to say. With that, let me jump into my slides. And Erin, if you could just give me a thumbs up that it's showing. Is it showing there? Great. Okay. One of the motivations for this particular training session was to help just depoliticize a little bit the conversation around COVID-19 and religious freedom. And there are two major problems that I see percolating throughout our society, particularly in the United States, but even in other countries. And one is that folks are reaching very simple, often political conclusions whenever they hear something about a church fighting against or trying to push back against a COVID-19 restriction. And this appears to be happening even among federal judges. So some recent research from a colleague of mine showed that of the 75 cases in which religious groups have challenged the COVID-19 restriction, the breakdown has been as follows. 100% of judges appointed by a Democratic president have voted against the religious groups. 100% of judges appointed by Donald Trump, these are federal judges, 100% of judges appointed by Donald Trump have ruled in favor of the religious groups, and 67% of judges appointed by other Republican presidents have voted in favor of religious groups. That 67% number actually sounds like in a relatively healthy range to me, but the 100% of judges on one side and 100% on other voting one way or another after making quick, simple conclusions strikes me as problematic. And it's a similar problem I see across the board. Anytime I have a conversation with someone, we reach the second problem that I see happening right now, which is people are making caricatures of both state actors and of churches. When a church asks for relief from a particular COVID-19 restriction, immediately they are characterized and are thought of as some church that wants to just completely blow off the pandemic as if it doesn't exist. They are made into a caricature of a group of people who are asking to have 400 or 500 folks gathered in a tight space, all touching each other with no masks and no social distancing. And when caricatures are made of state actors, they are often framed as people who have absolutely no interest in religion or religious freedom. and they're just trying to quash religion wherever they can. The reality is those caricatures are almost always wrong. They represent the most extreme positions of both state actors and of churches. And in between those extremes, we have 99% plus of churches and state actors who are simply trying to figure this out in a way that helps government meet what they think are important ends and helps churches meet what they see as essential and vital exercises of their religion. So my hope today is to help flesh out a little bit more of what the cases that are being litigated look like and how they actually should be approached, rather than people just reaching gut conclusions right out of the gate as to whether or not a church should win or lose. My initial response, by the way, is that if you hear about a case that a church is bringing against the government related to COVID-19, if your initial reaction is the church should either win or lose, and you don't know anything about the order that the government has issued, and you don't know anything about how the church is going to be meeting, you've reached your conclusion too fast. You really do have to understand the cases to avoid making the mistake of just jumping to conclusions too quickly. To understand this, you have to understand just a little bit of background about what we call the Free Exercise Clause. There are two clauses in the Constitution, there are three actually, but two that are somewhat relevant to this, that relate to religious freedom. One's called the Establishment Clause. I'm not going to worry about that today. The other one's called the Free Exercise Clause. And it says, Congress shall make no law respecting the free exercise of religion. That clause, from 1963 to 1990, it was relatively straightforward what the Free Exercise Clause meant. If government burdened someone's exercise of their religion, government needed to pass what we call the compelling interest test. What that means is government had to show that it had a compelling interest and that it was taking the most narrow means possible to achieve that interest. For those of you who are lawyers, this is a common test and you're familiar with it. We often refer to it as something called strict scrutiny. Let me just give an example of how the test played out just recently in a COVID-19 case. So this was the test again from 1963 to 1990. It still is the test in some instances today, and I'll get into why only in some instances shortly. But in Washington, D.C., the government had issued an order that restricted gatherings, and in particular church gatherings, inside or outside, it didn't matter, and it didn't matter how big the space was or whether or not people were engaging in social distancing or wearing masks, but it limited people to 100 or more, or it limited people to 50% of the space that they were in, whatever was lower. So if 50% was lower than 100, then they could only have 50% capacity, but they couldn't exceed 100 people. A particular church in DC recently tried to work with the DC government to try to get this resolved. They said, please, we have a big open space. We can have more than 100 people where everyone can properly social distance and still wear masks. This is a crucial and essential part of our religious exercise to gather. This particular church, it's against their theology. It's not against their theology to have online Zoom church, but there's no theological value in it to them. To them, the theological value and the commandment is to meet together in person. So they were trying to find a way to do this. Of course, the DC government responded and said, look, we have a compelling interest, as the litigation was proceeding, we have a compelling interest in protecting the health of people in the District of Columbia from the virus. And the church didn't dispute that that was a compelling interest. What the church argued was, yes, but you're not taking the most narrow means to get there. And you're also not taking your compelling interest seriously because you're allowing other meetings of far more than 100 people to occur all throughout DC as well. In that particular case, just recently, the federal district court ruled against the government of DC and said, look, this church can meet in a wide open space. People can properly social distance by household. More than 100 can meet at a time wearing masks. It won't undermine the government's compelling interest of keeping the residents in the district healthy. And therefore, under this particular test, the church should win. That's one example of how this should play out. Unfortunately, in 1990, there was a massive shift in the law, which makes the law that governs the free exercise of religion almost comically confusing. Those of you who have heard me talk about this before are probably somewhat aware of it. But in 1990, the Supreme Court, with an opinion, a 5-4 opinion issued by Justice Antonin Scalia, changed the law. The law shifted from being the compelling interest test, which is what I just showed you, to something quite different. There was a case involving this man here, Al Smith, and a question came to the court about whether or not government could make illegal a central practice of his religion. And I'm not going to get lost in the details of that case because we don't have time. Everybody who went up to the Supreme Court was making the argument that Oregon could not meet the compelling interest test. And everyone argued that. The case is really complicated, it went up and down, but eventually that was the arguments being made at oral argument. Everyone was arguing that Oregon couldn't meet the compelling interest test. Oregon was arguing that it could. And then the Supreme Court issued an opinion where they said, we are no longer making the compelling interest test the test that courts need to look at under the Free Exercise Clause. Instead, the test is this: if a law is neutral and generally applicable, then it really doesn't matter if it happens to burden someone's religious exercise. So what ended up happening is a massive shift across the board in the law. Courts now had to start asking themselves, is the law neutral and is it generally applicable? In response to this opinion from Justice Scalia, the Congress passed a law called the Religious Freedom Restoration Act that tried to restore the test, the compelling interest test. And the idea was it would restore it across the board. Well, that worked for a little while, but then the Supreme Court came and struck down a large portion of that law as it applies to state and county and local governments. So now what we have is a strange world where if you have a federal law, that law has to meet the compelling interest test that was in place before 1990. But if it's a state or more lower level law or regulation, it actually might have to meet the neutral and generally applicable test, or it might meet the compelling interest test. And the reason for that is a number of states have passed various mini RFRAs, what we call mini Religious Freedom Restoration Acts, to try to restore the test that was in place prior to 1990. Some states have interpreted their state constitutions to restore that test, and some states haven't done anything. If they haven't done anything, what that means, or in the case of Utah, and Alexander is the expert on this, in the case of Utah, they've reached a compromise bill on some things. But by and large, what we have is a world where the free exercise of religion is not protected the same, and it depends on where you are. That's where you are is what determines what law is going to apply. So you can see from this map, it's all over the place in terms of what states have passed laws protecting things. What we end up with is this. In the COVID era, in states with no protections for the free exercise of religion, no state laws on the books or nothing in their state constitution, we go to the Free Exercise Clause. And the question is the law neutral and generally applicable? But if we're dealing with a federal law or prisoners or religious land use, then we go to the compelling interest test, which was the law that was in place before 1990. Or if we're in a state that has its own state constitution has a clause protecting the free exercise of religion, we go to this third option, which could be the compelling interest test. It could mirror the federal test and whether or not a law is neutral and generally applicable, or it could be some middle of the road test. Finally, if you're in a state that has passed a statute protecting religious freedom and that mirrors the Religious Freedom Restoration Act at the federal level, then we ask again, if a law burdens the exercise of religion, can it then pass the compelling interest test? So you can see how confusing this is and what judges have to apply. To boil it down though, there are really two primary tests that get used again and again and again. One is whether or not a law is neutral. The first test is the law neutral and generally applicable? And if the law is not both neutral and generally applicable, then generally speaking, it's not going to stand. It technically at that point has to pass the compelling interest test, but it almost never does. The second question that courts may have to ask is, can the law survive the compelling interest test? As I set it out earlier when I was talking about what happens in Washington, D.C. These are all the different ways that courts have to look at a claim that religious exercise is being burdened. I want to unpack this question of whether or not a law is neutral or generally applicable. And the phrases essential versus non-essential when you're talking about the constitutional test are very misleading, and I'll explain why in just a little bit. As most of you know, a lot of these orders across the 50 states have allowed what the governments have called essential businesses and non-essential, essential gatherings and non-essential gatherings. Alexander's going to flesh that out a little bit more, but for purposes of whether or not a law is neutral and generally applicable, and thus whether it violates the Constitution, the characterization of essential versus non-essential is really irrelevant. And I'll explain why when I get into general applicability. So the first question, what does it mean for a law to be neutral? What we learned from a series of cases after the Al Smith case in 1990 is that a law is not neutral if it's actually targeting a particular religious group or religious belief. If there's, if it's hostile towards a particular religion or religious group, if it shows animus towards a particular religious belief or person or group, then a law is not neutral. And in that case, it'll most likely get struck down. General applicability, though, is a much more complex question. The question of whether or not a law is generally applicable hinges on a number of factors, and there's a series of decisions that have occurred in the 30 years since Smith that help us understand when a law is not generally applicable. A law is not generally applicable if it only applies to religions but nothing else. A law is not generally applicable if there are individualized exemptions. So for example, if a state passes some type of regulation to protect against COVID-19, and that regulation would allow some state actor to determine on an individualized basis which people have to comply with the regulation and which people don't, that law would not be generally applicable. A law is not generally applicable if there are non-religious secular exemptions to the law that endanger the state's interest in a similar or greater degree as the burdened religious conduct. That sentence is key, so I want to restate it. It's not whether or not the state has characterized something as essential or non-essential. The question is, has the state made a secular exemption to its COVID regulations that endangers the state's interest in a similar or greater degree as the burdened religious conduct? So if the state has made exemptions that undermines its stated interest in trying to protect the public health against the virus, then that law is not generally applicable. And in those types of situations, the state then has to provide the same type of exemption to religious institutions unless it can provide a very compelling reason for why not. And generally speaking, it can't. That's at least how the law is supposed to play out if judges are applying it faithfully. Now, this is why you don't, if you're a lawyer litigating a case like this, or you're a judge looking at it, you don't want to get caught up in whether or not a state government has labeled something essential versus non-essential. That doesn't matter. It might have labeled something essential and allowed it to be open, but if that essential gathering undermines the state's interest in protecting against the virus, then that law is not generally applicable. And as I say, it must protect churches as well. So when these cases get litigated, immediately what you're going to see happen is the church groups who are bringing the claims are going to be asking, are there other exemptions out there? Is the state allowing certain gatherings that are undermining the state's interest? And they're going to try and push that argument. So you'll see that as these cases get litigated, and you'll see churches looking for those types of arguments. The same type of argument often gets made in the compelling interest test cases, because what churches will often argue is that if the government truly had a compelling interest to protect against the virus, it wouldn't be making all sorts of exemptions that undermine that interest. So you often end up with similar arguments in both types of cases. Let me just give you a few examples that are percolating out there to help bring this to life a little bit. So let's look at this question of, is a law neutral or generally applicable? Nevada recently changed its order. At first, Nevada shut everything down. When we were in the early stages of the pandemic, if you recall, nobody really knew how bad this thing was going to be. We were seeing videos out of Italy of just coffins and bodies being taken out of morgues, and so everyone just shut down. But as time progressed and we came to understand it a little bit, Nevada started to ease its restrictions just like everybody else. And it allowed casinos to open in a way that hundreds and potentially thousands of people could be in casinos meeting. At the same time, it limited all church groups to no more than 50 people. So these various church groups went to the state government and said, hey, come on, we're going to follow all the social distancing. We're going to make sure we engage in all the right practices. We'll wear masks. We'll do everything we need to do to protect ourselves. But if you're going to let the casinos open, you got to let us open. And Nevada refused to change its order. And so these churches filed suit. And you can see how this plays out. The churches start arguing that this law is not generally applicable. If you're allowing the casinos to open up, and you're allowing hundreds, if not thousands of people to stream through them, you're undermining your interest in protecting against the virus. And therefore, you need to let churches, at least at a minimum, receive the same treatment as the casinos. Those are the arguments that are being made in Nevada related to whether or not a law is neutral or generally applicable. Another case out of Minnesota. There, early on in the pandemic, same thing, everything was shut down. And then, I don't remember exactly when, but I want to say May or June timeframe, the governor of Minnesota changed his order to allow more and more businesses and other things to open up. So he allowed movie theaters to have more people as long as they were practicing social distancing. His order allowed retail stores, clothing stores, places like that to open up. It was no longer just grocery stores where people needed to buy food, but it was all sorts of shopping. And he kept his order for churches at no more than 10 people. Churches were limited to 10 people or fewer. So what you had there, the churches didn't immediately file a lawsuit. What they did is the archdiocese there in Minneapolis and a number of other churches essentially sent a letter to the Minnesota governor saying, look, this is just wrong. We're going to follow all of the same protocols as a movie theater would. We're going to do everything we're supposed to. We are essential to the lives of our people and to their spiritual and emotional health. And you cannot allow 100 people in a movie theater and only 10 in a church if we're following all the same protocols. That just doesn't make sense. To the governor's credit, the governor got that letter and immediately said, you know what, you're right. We simply didn't think it through and changed the order to then allow churches to meet the same way movie theaters and other similar events were meeting. But you can see again, the arguments as to whether or not something's generally applicable are at play here, and the arguments as to whether or not there's a compelling interest. The important thing to note is anytime you hear about a case popping up somewhere in the United States, you really don't know exactly which law is governing. So the first question is it a federal rule? Usually it's not. In the case of COVID-19, these are almost all coming from the state level or lower. If it's not a federal rule, then you've got to ask the questions of what laws govern in the state. Is it just the First Amendment? In which case it would be the test from the Al Smith case, or are there other protections in the state that might change the analysis? The point is, none of these cases are the same, and you can't simply reach a gut reaction as to what should happen based on whether or not you think religion should always win or religion should always lose. Now, this is the last point I want to end on, and then I'll hand it off to Alexander. The test that I just walked through and the analysis that happens when these cases go to court, they are a floor. They are what happens when government refuses to work with various church groups to see if they can't find some accommodation that will work, and the churches are forced to sue. When that happens, then courts need to use these varying tests I've talked about to analyze the cases. But in many states across the country, more and more governments are recognizing, as the pandemic progresses, the value of religion. They are recognizing that shutting people down, keeping them out of their spiritual lives is actually contributing to the mental, emotional, and spiritual illness in our country, and that there is a compelling need to ensure that people are both mentally and emotionally and spiritually healthy as well as physically healthy. And so you're seeing certain states, at least, and certain governments try to work with religions to find a way to help them stay open while also meeting the compelling interest of trying to protect against the virus. Alexander now is going to talk a little bit more about this question of the importance of religion and what it really means and the value that it can bring to our lives. So I will stop sharing. I'll remind everyone, I see some comments coming into the chat. I'll keep an eye on those. And after Alexander's comments, we'll turn to the various questions. and start to look more at, where, or try to answer as many as we can. So Alexander, let me hand it off to you.
Thank you, Steve. That's a terrific presentation of the legal principles, and there's a lot going on there. And this issue has a degree of complexity. What I wanted to do is to step back maybe from some of the intricate legal discussion and talk a little bit about some of the concepts, some of the background concepts that have contributed to some of the tensions and to some of the caricatures that Steve has mentioned. And I think, as Steve has just mentioned, I think some of these are being fixed over time. And so I want to go back and take a little bit of a snapshot of some of what was going on right at the outset. Let me see if I can share my screen. And all right, Steve, can you see this now? Okay, he's giving me the thumbs up. As Steve has mentioned, early on especially, there was a lot of discussion about what is essential. And this was significant because they were trying to regulate in a context where they didn't really know all of the risks. So how bad is this virus? Is this like an Ebola virus? How deadly is it going to be? These are all huge concerns. So in the early days of the pandemic, there were efforts, and I believe they were good faith efforts. There were efforts to try to distinguish between what should be permissible essential services and activities, and then others that are non-essential and thus would not necessarily be permitted. And almost invariably, not always, but almost invariably, religious services, activities, and gatherings were deemed non-essential. Now, many of these orders permitted essential activities and services that at times seemed kind of hard to justify in the face of total bans on non-essential religious activities. In other words, as you started to look at the list of what was essential and then compared to what was not essential, you began to come up with some things that were maybe a bit questionable or might have caused you to kind of raise an eyebrow. So for example, essential services and activities, shopping at a supermarket was of course considered to be essential, important for obvious reasons. You need to be able to buy food and get supplies that are essential to be able to live. But of course, it wasn't limited to food. It was limited to, it included other things, consumer products and so forth. Well, that was reasonable enough. But you could also go to a special liquor store and buy alcohol. You could, of course, buy gasoline and then items at a related convenience store. You could visit a doctor, veterinarian, and obtain medical supplies. That makes perfect sense. You could counsel in person with a lawyer. Now, lawyers were drafting these, so they made sure to put legal services down as essential services. And you get your automobile and your bike repaired. I work in Salt Lake City. I'm on the 19th floor of the KeyBank Tower. And during this entire pandemic, there has been active construction on a huge building that is being constructed right across the street from me on State Street. None of that ever stopped. Those kinds of construction activities were written into the laws as essential. Dozens of workers, often congregating with each other, no masks on. Marijuana production and dispensaries considered essential. The media, for very good reasons, they have First Amendment protections. Laundromats, dry cleaners, real estate services, even pawnbrokers and private detectives, and so forth. Working for one of these businesses was also considered to be essential. Outdoor recreational activities, including walking pets, educational institutions, and eventually protests were deemed essentially, to be essential services or part of this group of things that the government wouldn't regulate. Now, many of these things make perfect sense, of course, but there were fairly rigid restrictions on other kinds of things, especially religious things. So worship at a house of worship was barred in a number of states early on under any circumstances. As Steve mentioned, later on that began to open up, but initially at these during these stay-at-home orders, it was completely barred. Language such as this was fairly common. All public private gatherings and multi-person activities for spiritual purposes, regardless of the number of people involved. You kind of contrast that with what was going on at supermarkets. I'd go to Costco, and there'd be large numbers of people, and they were supposed to socially distance. Often they wouldn't. There could be several hundred people within my local Costco, but you couldn't get together under any circumstances whatsoever as part of a religious gathering. I thought this was interesting. Remember earlier on, I mentioned that you could get together and counsel with a lawyer, but you couldn't get together and counsel with a bishop or a priest, and you couldn't participate. This was very painful for Catholics. You couldn't participate in last rites, even if the priest was, wearing PPE, was, masks and gloves, and didn't even touch the individual. The Catholic Church had a special dispensation for using a Q-tip to administer the oil, and in a number of places that was just considered not acceptable. Baptisms, weddings, funerals, typically they'd have an exception for a commercial funeral home, but you couldn't have these inside of a church. Door-to-door proselytizing, that was kind of an obvious one. So a lot of this was driven and is driven by how we think about religion, and I think that does, even in some respects, have some impacts on the compelling interest test. When a judge is sitting down, especially individual judges, and Steve mentioned this kind of ideological divide, when they're sitting down and thinking about a religious organization and what it is and how important it is to be religious, I think some of these concerns, some of these concepts about what religion is, I think they play a significant role. And I think there are some significant misconceptions about religion and its role in the life of the believer. Some, I've listed a few of these. Some people conceive of religion as some form of a hobby or a pastime, maybe even something that's personally important, but not necessarily essential to the individual. Some have even darker views, of course, of religion, that it's nothing but kind of a superstition or ignorance. And so, while under ordinary circumstances, it's fine for people to have religious freedom. If there's something important that is going on, the government needs to limit that. Really, it's not that big a deal. Again, these are broad strokes here, but some of these kinds of concepts do filter into what policymakers are doing. Now, the reality is that for many people, religion is indeed an essential aspect of human existence and human flourishing. It is defining in terms of identity. It is unifying. There is power in coming together. That's very meaningful. It provides a great deal of peace as well. This is a comment from Elder David A. Bednar from the G20 Interfaith Forum, which he participated in yesterday. And he said this: for billions of people around the world, religion is the very center of our lives and the core of our identity. Our faith calls upon us to love God above all else. It defines who and what we are, how we understand the meaning of our lives, and how we live each day. It is the source of our strength, consolation, and hope. Faith traditions are the incubators and shapers of family and community life, creating and sustaining the spiritual ties that link and bind people together. Religion transmits moral and social truths to the next generation. Our faith is more than just important to our dignity as human beings. It is essential. Now, Elder Bednar has been criticized as suggesting in this talk and in others that the government shouldn't be protecting people from the coronavirus. That's just not true. In fact, in his talk, he says this, I'll quote from his talk, I got it up on my screen here. Governments obviously have a crucial role to play in protecting people from the coronavirus, and I applaud the sincere efforts of government officials around the world to do so. As with secular activities, religious activities should be carefully limited when truly necessary to keep people safe. We'll tie in into something Steve said, is this really necessary? No one has a right to spread a dangerous virus, but that is not the end of the matter. How secular officials understand religion and religious people deeply influences how they treat religious institutions and believers in a time of crisis. And this is his main point. The deeper and more respectful the understanding, the more legitimate and effective public policy responses can be. So as we think about what's essential or what's most important, we need to take not just a short-term view of this. And of course, sometimes you have to take a short-term view when a virus is exploding. As we now understand this virus, it's important to take a longer-term view. And here it's important to realize that if we cut people off from their faith tradition, that we're cutting them off from great sources of strength. As Steve mentioned, this has significant long-term consequences. We're in a long-term pattern now with this virus. And so there need to be sensitive tools here, because otherwise we might trigger results that in some cases are just as bad as the effects overall of the coronavirus: depression and isolation, suicide, drug and alcohol abuse, acts of physical and sexual abuse, and then our youth and their moral education. So these are very serious consequences of just cutting people off from their faith community. And I think that is now recognized increasingly by public officials. So to say that religion is essential or vitally important, that of course, that doesn't dictate exactly what to do with religious practices during a pandemic. It really is just the starting point for the right sort of mindset that you need to have. We understand, of course, that food is vitally important in a pandemic. It's vitally important always, and therefore we make accommodations to obtain food. That's an obvious recognition that we have. But what if we understood that for tens of millions of people in the United States and beyond, religion is absolutely vital to their existence? That doesn't tell us, the kinds of safety precautions we ought to have, but it does put us in the right framework for discussing these sorts of things. And so the call, and this is Elder Bednar's call, and I think it's significant. I think this is what the faith community is asking for. The call is for recognition, respect, and accommodation where reasonably possible. It's a call for recognizing the health of the whole person needs to be taken into account: body and spirit, our emotional health, our mental health, the health of our relationships. This mindset was often missing, not always, but often missing in the early thinking of health officials as they were trying to draft these orders. And again, I don't necessarily fault them. They were in the middle of an early crisis, but then as they began to loosen up, sometimes they began to loosen up much more quickly on secular interests, things that they better understood, even things like casinos, as Steve has mentioned, and were very slow to loosen up when it came to religious situations, religious gatherings. Again, Elder Bednar, because I think this is a really great point. The deeper and more respectful the understanding, the more legitimate and effective public policy responses can be. Surely, at least part of the crisis of legitimacy in the response to COVID-19 arises from the failure of some policymakers to account properly for the centrality of faith of religious believers, faith in the lives of religious believers. So it's more of a holistic approach. And so just kind of as a final point, and this is something that I hope policymakers are coming to understand better, and I think they are, and that is that faith communities really are part of the COVID-19 solution. Not only do they sustain people during the long haul of trying to get through what is, of necessity, some amount of isolation. But they can also calm people's fears. They can urge people to stick with it, to stay with safe behaviors, and they can really help dispel misinformation and rumors. I think some people forget that polio was essentially eliminated in large part when it came to Africa and areas in South America and in Asia, because of the influence of faith leaders who were connected with public health officials. They worked to dispel misinformation and rumors and fears, irrational fears, that these vaccines would essentially destroy people's lives. That's the sort of vision that I think is far more productive as we look at it. And I think, I think whether that is fully compelled by the Constitution, certainly at the outer limits, government has a responsibility to accommodate religion to a significant degree, and certainly not to target it, and certainly not to burden it with special disabilities. So, Steve, we'll get back to you for questions, and look forward to maybe answering a few of those. Thank you.
Great, thank you, Alexander. And we have had lots of questions come in. There's two that I want to answer that are very quick that I'm going to answer, and then I'm going to throw one your way because it's much harder, Alexander. So the easy question was from Brian Josephson. He asked if the percentages I referred to earlier, which I assume are the percentages related to judges and their rulings on various churches, if those are referring to the LDS Church or churches in general. I was referring to all of the litigation up to earlier this week related to COVID-19. I'm not even aware if the Latter-day Saints have even been involved in any of that. That's all churches across the United States. So as far as I know, the church has not actually been involved. The other question that I wanted to hit on was someone said, I don't understand, how can these clauses override the Constitution's original intent for the free exercise of religious freedom? I just want to show everyone real quick. I'm going to share my screen again and show you, if you really want to get a sense of the history of the Constitution's protection for religious freedom, you'll find that it actually has not been protected that well throughout US history. So from 1790 till about the 1940s, by and large, the Supreme Court had read out of the Constitution protections for religious freedom. And the key cases actually occurred in the 1890s, and they involved the Church of Jesus Christ and the practice of plural marriage. Essentially, in those cases in the 1890s, the Supreme Court made it the constitutional rule that the practice of religion couldn't be protected if the religious belief was repugnant enough to the majority. And that was kind of where things sat well up into the 1940s. And during this period of red here, a lot of religious minorities, and in particular Native American faiths, suffered and suffered greatly. It wasn't until around the 1940s, 50s, 60s that we started to see a thaw. And then the Supreme Court really read into the free exercise clause of the Constitution significant protections for religious freedom. And then again in 1990, those arguably got read out. So just to give you a sense of this, the United States has not really been consistent as a nation in truly protecting the free exercise of religion over time for religious minorities. And it's something that every country on earth has to continue to fight for and try to achieve, and do it in a way that protects everyone at the same time. We've done well in periods of our country's history and not so well in other periods. With that, Alexander, let me send a question to you, because I think this is right up your alley. Somebody asked if there is out there, and this person appears to be a state representative from somewhere, model language for RFRAs, if states are looking to put these in place. Obviously, you've worked not just on RFRAs, but on Fairness for All Acts and everything else, so you could talk about this better than anyone on earth.
Yeah, it's a good question. Different states have taken different approaches. The approach that I would recommend is actually fairly simple. I would take the federal statute that has been in existence since 1993, and I would have it tweaked just slightly by your legislative council to make sure that it maps appropriately onto state law. And that doesn't mean a lot of changes, and I would go with that. The reason is that state RFRAs that are anything other than what the federal RFRA is, and even if they are just the federal RFRA, have become enormously controversial. They become tied up in the whole LGBT religious freedom debate. And I think it's probably the best thing you could do is probably just to copy the federal provision. And there has been some success in getting something similar to the federal provision through, recently, I believe in Georgia, they might have passed something like that, or at least it had majority support to go forward. Anything else is likely to get swamped in the whole LGBT, religious freedom debate, and that's fairly bitter at times. So, I'd also be happy to help out to discuss that offline as well.
Great, and I would emphasize the particular genius in following the Federal Religious Freedom Restoration Act. Is that the whole purpose of that act was to put back in place the test that was there before the Al Smith decision. So nobody can claim you're trying to create something that wasn't already in place. The test was there from 1963 or so to 1990 and served the country well. The purpose of that statute was simply to put that test back in place. It's not some new invention that's meant to harm anyone or anything like that, which isn't exact.
And not only.
Go ahead.
Yeah, and not only that, sorry to interrupt, Steve, but not only that, but despite some of the rhetoric against the Religious Freedom Restoration Act, it really hasn't produced any truly radical results. There's been some consternation over the Hobby Lobby decision, but in reality, that was a quite narrow decision. There was great fear that was going to metastasize and lead to corporate America being able to invoke RFRA and just get out of various regulations and so forth. We haven't seen that, and Hobby Lobby just involved a small handful of contraceptive drugs. There were many others that were nevertheless made available. So there is a lot of fear, and there's a fair amount of negative rhetoric now surrounding RFRAs. But the reality is the federal RFRA has withstood the test of time. It has worked well. Religious claimants do not automatically win, but it does force judges to dig in and do just what Steve has talked about, to really take a look at whether the interest that the government is advancing is truly, truly important, and whether the government can advance that interest through some alternative means that doesn't burden religious exercise. That is, after all, how we ought to be thinking about and treating one of the most fundamental rights that we have.
And I would just say, during the years, those 3 decades when the compelling interest test, the RFRA test, was in place, religious claimants actually only won about 40% of the time on their claims, to echo Alexander's point. Courts were really looking carefully at this. A lot of the times when religious claimants were losing involved situations with prisoners' rights or in the military, situations where the state's interests are really at their highest. But the point is what Alexander said: courts were forced to really look at this, take the religious claims seriously, and analyze them properly. And, doesn't mean they got it right every time, but at least they weren't allowing their own biases to simply take over with a gut reaction. Let me give you another question, Alexander. This is the very first question, so it deserves to be answered. Someone says, Elder Bednar of the LDS Church has repeatedly cautioned government to respect religious freedom, but what can we do to actually prevent government from infringing upon our freedom of association and worship in the present environment? What are your thoughts on that?
I think the first thing that you can do is encourage people to act responsibly, especially when they're acting in the name of religion. Nothing hurts the cause of religious freedom more than religious people doing stupid things and giving fodder to those whose own personal inclinations tend to be very suspicious of religion. So early on, there were a number of religious groups, not very many, a small number of religious groups that just said, we're going to meet no matter what. And that became an easy metaphor for, religion is disrespectful, religion doesn't care, religious people are, fanatics, they're benighted, and so forth. Now, it didn't happen very often. And yes, there were a few instances where those gatherings resulted in the spreading of the coronavirus. That was also true of all kinds of other gatherings that were spreading the coronavirus. I mean, the virus didn't just spread because a small handful of religious groups disregarded, government regulations. It spread for a lot of reasons, but it was it created an easy target. So first, I think we need to be responsible citizens, and that's just vital. Second, I think when there are injustices, when there are obvious inconsistencies, we need to respectfully bring them to the attention of government officials. Most of them don't want to suppress religion. And in my experience in interacting with government officials during the last 6 months and trying to work through some of these things, if you can show them that what you're doing is going to be safe, it really doesn't pose any health risks. And in fact, and this is what we've done a number of times, we've shown them that what it is that we're doing is actually safer than other things that they allow. I don't know about your experience, those of you who are members of the Church of Jesus Christ of Latter-day Saints, but my experience in going to sacrament meeting is that is one of the safest places that I go to. Everyone is in mass. Everyone is spread out. Nobody's singing. Nobody's speaking loudly. And it's a fairly short meeting. People file out afterwards respectfully. There are all kinds of other things that are lawful that are going on that, to me at least, seem a lot riskier than that meeting. And I think showing public officials, the reality that religious activities can occur in a safe way and be just as safe as other activities, I think that's very, very helpful. Responsible, I think too often, especially as lawyers, too often we think that the solution is lawsuits or kind of ultimate rhetoric. You are violating my fundamental rights. We kind of move instantly to this very heavy artillery of the First Amendment, which I support. I mean, I've spent most of my career trying to bolster that artillery and sometimes having to use it. But very often we can go in and sit down with public officials, make legislators and the governor's office aware of legitimate concerns and inconsistencies. Quite often we'll get quite a ways, especially if we have others with us. So that would be my solution.
And I don't have anything to add other than to say the caricature that I mentioned at the very beginning of my remarks, that there are caricatures of churches out there and the way they behave. Those caricatures actually did come from somewhere, and they came from that very, very, very tiny sliver minority of churches who were acting irresponsibly, as Alexander said, mostly at the beginning of the pandemic. It made it much easier for people then to characterize every other church group as being the same way. So I echo that comment of the importance of responsibility. And the only other thing I'll say is many of these orders are coming at the county level. That means the government officials who are issuing them are not that hard to access. It's not as if you've got to go to the US Senate or Congress or the president and speak to someone. These are people in your backyard, and you have every right to go and talk to them. And as Alexander says, make sensible and reasonable comments. We're out of time. Let me just thank everyone for being on, for being engaged. The questions were wonderful. I'm sorry we couldn't get to all of them. We tried to get to as many as we could. I'd like to thank Aaron for hosting us. And please don't hesitate to follow up if you have questions. We will try to make our slides available through the JRCLS website and look forward to hearing from you. Thank you so much.